Hello, everyone, and welcome to the 10th day of coverage that we've been doing of Julian Assange's extradition trial. We did not have proceedings that went as planned today, but I think that's part of the story. So let's get right into it. We had Christian Grothoff, who is a computer science professor in Switzerland, who was called to the stand. We were also supposed to get Jacob Augstein, who is a journalist with Der Freitag. And this goes to an episode in the WikiLeaks story that I'm not sure a lot of people are very familiar with, but it certainly has become a crucial part of the U.S. prosecution's case. What they claim Julian Assange did to put people's lives in jeopardy when unredacted cables were published to the WikiLeaks website. And what they leave out very conveniently to their indictment is that David Lee had included the password for this unredacted cable cache to an encrypted file that was available on the internet, that he put this in a book that was published about WikiLeaks, which he co-authored with Luke Harding of The Guardian. And they do not talk about the fact that this was available in a book that I assume was available in many, many bookstores, and that someone could eventually take that passphrase and put two and two together and find the encrypted file online. WikiLeaks was under a denial of service attack on after November 29th, 2010. That was reported. It was covered by Wired Magazine, other outlets highlighted it. It made it hard for people to access the material. And WikiLeaks had a practice of encouraging others to mirror their website so that the archives they had of material could be accessed by people who cared about these documents. And so as time progressed into 2011, while WikiLeaks was in the process of still partnering with media organizations, continuing country-specific reporting, working with journalists inside countries on specific cables in order to put out stories that had the most impact, eventually it became clear that this could be connected, that with Der Freitag particularly, we did not hear from Jacob yet, but we would get this if Jacob had taken the stand, that they had started to do journalism to show that this encrypted file was online and that David Lee's password, in fact, could be used to open it. But that wasn't something that WikiLeaks had tried to advertise. They did not want these cables to be out there for everyone to access because inside of them, they understood, was material that had not been dealt with. So they redacted the war logs. They treated those names, people in there who were sources, anyone who might have been vulnerable, they treated that with sensitivity. It goes without saying that they would have had the same procedure with the cables. And in fact, that was true. You go to a week before the cables eventually were lost and there was no more control. And it was very obvious that they were going to need to just confront the fact that this was out of their hands. And so in the last week of August, we had unclassified cables that were being published. This was something that Christian Grothoff testified about, how even into the last week before it finally spiraled entirely beyond WikiLeaks control, they were still putting out sets of documents, and they were unclassified. They were not the secret cables or the confidential cables that might have had names for strictly protecting. I stress again that the prosecutors did not provide any examples of these standard releases where people's names were put in jeopardy. So again, we have the defense undermining a core argument of the indictment, which is that Julian Assange was putting lives at risk with these releases and engaged in actions that were different somehow from the journalism being practiced by media partners like the New York Times or the Guardian or anybody else who might have been working on these diplomatic cables, who the government theoretically would try to go after if they really believed what they were saying about the sensitive material in these cables. So we get some more testimony from Christian Grothoff about the way in which this played out. And eventually, by September 2nd, you had WikiLeaks owning the fact that this was out of their control, and people were now accessing the archive of material on their own website. And this was not the original intent. Der Spiegel had done an article about what happened with this material. There was an independent person who put up their own postings on their own personal website, Nigel Perry, connecting this and figuring it all out. And it wasn't the case that when they mirrored websites and when they spread this around to other places that they had wanted this encrypted file to be compromised. I'm not exactly sure what the prosecutors were trying to do with Christian Grothoff. It doesn't appear to me that they made much of a point when cross-examining him. Nonetheless, he took the stand, and they tried to argue that first he was biased because he had signed some open letter in 2017 urging Donald Trump to drop the grand jury investigation to clear Julian Assange of charges. And he was among, we learned during the re-examination that the defense put on that, in fact, he was among many names. It was former CIA, former U.S. military, human rights activists, judges, people who were in the German parliament had all signed this. So, but I stressed at that time in 2017, it wasn't something that was that huge of an imminent problem. We didn't think Julian Assange was going to be indicted as much as it became clear that would happen in 2019. And so he forgot. He says that he didn't remember that he'd ever put his name on the open letter. And also, what does it really matter? And he was challenged on this. And I think the challenge, the fact that the prosecution decided to make an issue out of this open letter that he couldn't recall signing, gave him the opportunity to state very clearly to the prosecutors that he felt that the prosecutors were unfair in the way that they had put together this indictment, because they did not look at the timeline and were inappropriately in their indictment accused Julian Assange of losing control and publishing this sensitive information, this unredacted cable cache. But they leave out everything related to David Lee in the indictment. And it's just not true. It creates a misleading narrative of events. And Grothoff, having been challenged about his bias, said, that's one of the things I was brought in to look at objectively, without bias. I was brought in to look at the timeline and to show through evidence that, in fact, WikiLeaks wasn't the one that published. I glossed over it. I didn't mention, but Cryptome, a site known for having a bunch of leaked documents on their website that aren't really curated at all. They're just listed by date. They had the entire archive posted to their website before WikiLeaks did. And so then the prosecutors brought up this editorial that WikiLeaks wrote, and they seemed to be suggesting that by sharing this editorial through their Twitter account and calling attention to the archive, that now they were somehow responsible for making the situation worse. And we got to the re-examination, and that was when we saw the fundamental issue that the defense is going to have to grapple with going forward, which is that we're now apparently on the judge's time, and the judge is going to heavily scrutinize everything that the defense happens to do, because she believes that this is going to take longer than the 4 weeks. And I think that's actually fair in her assessment, but the way she's going about handling and trying to manage it suggests to me that it's going to end up making it difficult for the defense to complete what it had planned to do for this extradition trial, because she stopped Mark Summers, who is a defense attorney, and didn't allow him to go on and re-examine the computer science professor in the way that he had wanted after the prosecution had their time with him. And so he didn't get to reset and refocus the judge, as is typical in these proceedings. And she said, "Why do you need to do this?" And he said, "Well, I believe that what the prosecutor is saying is that the WikiLeaks editorial made it so that more people would be able to find the passphrase and access the cables, and that they played some role in jeopardizing and endangering lives, and that that's not true. And so I want to show how that couldn't be the case." And then she said, "Well, I don't think that's really fair." And the prosecution even stood up and said that wasn't what they were trying to argue. So it was kind of a mystifying exchange that took place in the courtroom, because they seemed to back away from the line of questioning that they had pursued with Christian Grothoff, the computer science professor. And I know that might all be kind of confusing, but eventually it, in my view, somewhat benefits the defense, because they were able to throw out a sort of canard that was being pushed by the prosecutors. And so eventually it concluded that, WikiLeaks really wasn't doing anything that wrong to make it worse by calling attention to what had happened with the cables. So I'm not really clear where that leaves the prosecutors' allegations related to this particular charge. I'm not really sure what related to the offense is bought on the part of Bretzer at this moment, but I think that this was a good witness to have take the stand. We would have had Jacob Augstein come and take the stand, but he had to catch a flight at 1 o'clock, and I believe he was in Italy, and so they were unable to still have him be a witness today. I guess I'll pause for a moment and just say, right now, as I'm moving through the day's proceedings, beginning to get to the end of what happened on day 10, if you have any questions for me and would like them answered, I'd be more than willing to give your questions attention. So if there's something you want me to talk about here as I'm finishing up, just let me know. So before we went to lunch, we had this turn of events where the Judge Bretzer made it very clear to the defense that she is upset with them because they have not been able to schedule witnesses. And that's somewhat unfair to accuse them of prolonging the trial, in my view, because there are some things that have been entirely out of their hands. For example, I'm not sure it's reasonable to blame them for the COVID scare that happened on the part of the prosecutor, who it turned out simply had symptoms of a common cold. Now, they should take it seriously, as this is a global pandemic that this trial is taking place under, but at the same time, that forced a rearranging of all the witnesses. Everyone has fluid schedules, and it was difficult to get people back on the calendar. And some of these are very mundane issues. It doesn't have a lot to do with whether or not Julian Assange is going to be extradited or not. But why it does matter is because it's going to affect the way the judge allows the defense to call witnesses. It's going to mean that she's more restrictive about what the defense is able to ask, because she does not want this to go on past the 4th week. She wants this to be done and not spill over into October at all. And so she brought the defense forward, and she complained. We were going to try and hear from Andy Worthington, who is a journalist who worked on the Guantanamo files, which were the detainee assessment briefs that were disclosed. And the defense told her what they wanted Andy Worthington to take the stand to discuss. They could not agree on his testimony with the prosecution, so he will have to take the stand to be cross-examined. But yet they were scolded, essentially, for trying to fit him in. They didn't find out until last night that he would be available. They told the prosecution. The prosecution did not have enough time in the morning to prepare, but somehow it was their fault that they were giving the prosecution short notice, when I'm not sure what they could have done differently under these circumstances. They've been trying to find witnesses so that we don't have downtime, so we aren't just sitting here. In the afternoon, eventually we did get to this statement that comes from Cassandra Fairbanks, who is a conservative, a pundit, a kind of right-wing reporter, a supporter of Julian Assange, somebody who has supported Donald Trump's administration, who has been on DM groups. She apparently was on a direct message group that involved Arthur Schwartz, who's an associate of Richard Grenell, who was an intelligence official in the Trump administration, I believe. And this individual, Arthur Schwartz, is someone with some fair amount of influence in the Trump administration, someone who I think is rather close to Donald Trump Jr. And so he was talking to her about the plan that was going to be put in place for dealing with Julian Assange, to remove him from the embassy, to drag Chelsea Manning before a grand jury, and how that was going to unfold. And I understand Grenell was somewhat involved in brokering the outcome with the Ecuador government that led to Julian Assange's expulsion. And so she was shedding some light on that, and also sharing the fact that she went to visit Julian Assange. This was before he was, this was in January 2019. And I think she had a couple visits. One visit, she told him that this information that she was able to glean, this might have been in 2018. I don't think this has to do with UC Global anymore, because they had moved on to another company, but it shows the kind of surveillance that was going on, the pressure campaign to get Julian Assange to leave, and their conversation where Cassandra shared details with Assange, allegedly made it back to Trump administration officials. And she's asserted that she believes that then she ended up being harassed or intimidated, or told that she no longer could be trusted because she had spoken to Julian Assange about what she had learned from Arthur Schwartz. And then she was threatened. She has a child. Apparently, an editor, someone at the publication she works for, had worked for, the Gateway Pundit, was told that they should do something about her. I think she was suggesting that it was a threat to have her fired, that Grenell wanted something to be done because she was revealing what the Trump administration's plans were with Julian Assange and trying to intimidate her. And so we heard this information. This was something that was shared. It was a statement entered into court. They decided not to call her to the stand for cross-examination. The only thing they really disagree upon is whether being a Julian Assange supporter would undermine the nature of what she is trying to share with the court. The defense says that it's the truth of the matter asserted, while the prosecution would suggest that maybe she's giving it importance that it shouldn't have because she's a supporter of Assange. Nonetheless, it is clear that she appears to know, before anything happens to Assange, before even people in the WikiLeaks team know, she appears to know what Donald Trump's plans are going to be for indicting and expelling Julian Assange from the Ecuador embassy. So it is an important thing. And thanks, Chris. He was the acting director for the national director for ODNI, for the director for national intelligence. So we've got some questions here. And Jeremy says, do you think prosecution has been trying to purposely waste time in order to prevent testimony? Will these witnesses be allowed in the appeals process, or is this their only chance? So I can answer the second question first. That one is that anybody called, you want to call all your witnesses now, there aren't going to be witnesses on appeal. On appeal, you would argue different aspects of process, whether it was abused, did the judge not give you a fair and open hearing, and you'll run down the list of the different problems and alleged improprieties that might have taken place, or irregularities might be another word we could use. And then I don't believe that the prosecution is wasting time per se, but let's just be fair to both sides here. It's been cumbersome to try to conduct this trial during a pandemic. We are not all at the courthouse. There are things that they have had to deal with because we are doing it under these conditions. Witnesses are not there. They are not traveling. There are people in the United States who are 6 to 7, if not 8 hours behind. You can't have them get up at 3 or 4 in the morning to testify. So we have to wait until the afternoon, but maybe in the afternoons, they are not available. So then you have to try to get them on another day. Maybe they're available, but they're only available for an hour. So if the prosecution demands to have them for 2 to 3 hours, then you can't schedule them for a particular day. The prosecutors have wanted almost limitless time. They wanted unlimited time with these witnesses. Unlimited time. There were 2 U.S. attorneys in the United States that they had a total of 6.5 to 7 hours with, Eric Lewis and Carrie Shankman. Both of those people last week have no personal involvement with Julian Assange whatsoever. There is nothing that they were going to testify about working on the publications. They haven't represented them as Julian Assange's personal attorneys. They haven't directly been involved in the legal strategy for defending Assange while he was in the Ecuador embassy. They tried to link Carrie Shankman to Michael Ratner, but he never was involved in doing that work. That was all Michael Ratner, who is now, he tragically died from cancer in 2016. So these people were there on the stand as experts to talk about the Espionage Act, and then to talk about the way people are sentenced in the federal court system, how they are treated in prisons, the kinds of measures and conditions that might be imposed on Julian Assange during pretrial confinement. These are all very standard issues. And what we had was a very long drawn out cross-examination from the prosecutors, where they didn't really use it that efficiently, and yet the judge didn't object. She gave them lots of leeway. And if you want to know why we haven't gotten to more witnesses at this point, that certainly is part of it. We also have prosecutors that are dropping defense bundles on defense witnesses less than 24 hours before they're supposed to be cross-examined on that material. And those are 350 pages of material that they are going to ask them about, and they have no time to prepare. So when it gets to them, you're basically seeing that they are going to read that material to the witnesses, and live in front of our very eyes, they are processing what that might mean and trying to deal with the prosecutor's questions. So the judge is actually not getting the best testimony from them, because the prosecutors are taking so long to get that material to defense witnesses. And that has prolonged the proceedings. So today we really wasted about an hour to 2 hours trying to sort out these scheduling issues. And I don't know that it's fair to blame either side, but if we're going to go and start talking about what the defense isn't doing, you certainly have to make sure we don't take our eyes off of what the prosecution has been able to benefit from in these proceedings. I thought the policy was going to be to ensure that both sides got a lot of leeway, that the defense would get to call the witnesses they wanted. They would have their basic time. They'd put their statements into the record, the evidence. The prosecutors would get unlimited time to challenge whatever they wanted to challenge, and then the defense would come back and refocus the judge on what was important and what was noise. And so she didn't have to pay attention to things that didn't make sense that the prosecutors were trying to argue. But she's clearly going to try to speed this up, and I do feel like the pressure is going to be on the defense to manage it, because she is now interrupting the proceedings to claim what is repetitive and try to shut cross-examinations down. So We've got some comments. We've got some questions from all of you, and I thank you for following. We have a question about if there's a list of witnesses who will testify for the rest of the week. I'll just simply tell you that what we expect to have for the rest of the week are some doctors and or psychologists or people who have assessed the mental and or physical health of Julian Assange. We probably will hear from Dr. Sandra Crosby, who's a doctor who had met with Julian Assange while he was in the embassy. These will be important witnesses for the legal team to put on. Question about whether there are protesters outside the courtroom building. Yes, there are protesters that are there. There's at least 50 to 100 any given day. There are people who are coming to the court to support Julian Assange as well. There's no plan for Edward Snowden to testify. I don't think he's on the list. And I'm not sure that you would want to put him on the stand necessarily because he's accused of violating the Espionage Act, and then the prosecutors could probably do a fair job of impeaching him from wherever he in Moscow chose to do the court cross-examination. So I'm going to wrap it up here. We're coming up on 30 minutes, and I'm going to have a written report for you on what was important from today. And also, again, if you would like to get that written report in your inbox, and we probably have another week and a half of these proceedings at least, you can go to dissenter.substack.com/subscribe, and it'll come directly to you. You don't have to do any work. It'll be right there for you to read. Then there are these video reports, which I encourage you to share. And also I'm doing the live tweeting at Kay Gastola that you can watch. So again, I thank you for following these proceedings. And how about we leave with some words from Lula in Brazil. We've had some support from world leaders that have come forward to oppose the extradition of Julian Assange. We have Lula now contributing a editorial to the Guardian that was published, and he highlights what is happening. He says, "We must keep this outrage from happening. I call on all those committed to the cause of freedom of speech in every corner of the world to join me in an international effort to defend the innocence of Assange and demand his immediate release." And he articulates the issue with the Espionage Act and the fact that Chelsea Manning published these documents. And Lula continues, "We all know why the U.S. government wants to seek vengeance against Assange. In partnership with the New York Times, El País, Le Monde, and the Guardian and Der Spiegel, Assange revealed the atrocities and war crimes committed by the U.S. during the invasions of Iraq and Afghanistan, and the torture to which the prisoners in Guantanamo were subjected. The world also remembers the terrifying video published by Assange, recorded from a military helicopter, showing U.S. soldiers strafing the streets of Baghdad, apparently for the pure pleasure of it, among them 2 journalists from the Reuters news agency," which we actually heard from Dean Yates last week. He was the Baghdad bureau chief, and he had a statement that was entered into the record. In addition to all of these reasons, Brazilians owe an additional debt to Assange. Files published on his WikiLeaks page revealed conversations that took place in 2009 between those who would later be in the Temer administration, which in 2016 deposed the Dilma government, and top officials in the Department of State about questions related to the privatization of Brazil's deepwater oil deposits. It was through reading the documents revealed by Assange that Brazilians learned of the relationship between the man who would later be Minister of Foreign Affairs in the Temer administration, Jose Serra, and executives in the North American oil giants ExxonMobil and Chevron. The charge adopted by the Trump administration to justify the allegations against Assange, he describes these as both dangerous and false. And he raises the fact that Glenn Greenwald was almost charged in a case that mimicked the kinds of charges that were brought against Julian Assange. And then he concludes, we know that the accusations against Assange represent a direct assault on the First Amendment rights guaranteed by the U.S. Constitution, which guarantees freedom of the press and expression. We know that treaties between the U.S. and the U.K. prohibit the extradition of persons accused of political crimes. The risks that Assange will be extradited, however, are real. No one who believes in democracy can allow someone who provided such an important contribution to the cause of liberty to be punished for doing so. Assange, I repeat, is a champion of democracy and should be released immediately. So, with those words, I wrap up this broadcast and invite you to join me tomorrow after court for another live video report. Until then, thank you for all the support. Thanks for following my reporting. I could not do this work without all of you. And I will talk to you tomorrow.